Hello, can I be heard?
Testing. Everyone hear me?
Yes.
Excellent. Thank you. All right. We will just wait for Commissioner Maggio for another moment or two. Okay, it is 7 o'clock. We will get started. At this time, I would like to call this meeting to order. Tonight is Thursday, October 14th, 2021, and this is a meeting of the Rent Stabilization Commission for the City of West Hollywood. Commissioner Montemayor, would you like to lead us in the Pledge of Allegiance, please? Sorry if I made you go last time or recently.
You did, but I relish in it.
And I'll note that Mr. Commissioner Maggio is here.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, for liberty and justice for all.
Wonderful. Thank you very much. Mr. Secretary, may we have a roll call vote, please?
Commissioner Ayers,
Here.
Commissioner Kirby's,
Here.
Commissioner Maggio,
Here.
Commissioner Montemayor,
Present.
Commissioner Topshin,
Present.
Vice Chair Copeland,
Present.
Chair Marks.
Here. Thank you. We have a quorum. Has everyone had a chance to review tonight's agenda? I see excitement. All right. Do I have a motion and a second?
Motion to approve the agenda?
I'll second.
Second.
May we have a roll call, please?
Commissioner Ayers,
Yes.
Commissioner Kirby's,
Aye.
Commissioner Maggio,
Aye.
Commissioner Montemayor,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Copeland,
Aye.
Chair Marks.
Aye. Thank you very much. The motion passes. Moving right along, we have the minutes from our last meeting, which was on September 23rd, 2021. Has everyone here had a chance to review those? I'll take that silence as yes. If we have a motion in a second.
So
Motion
moved.
to approve.
I'll second.
There we go. We have both of those. May we have a roll call, please?
Sorry about that. Commissioner Ayers,
All right.
Yes. Yes.
Commissioner Kirby's,
Yes.
Commissioner Maggio,
Yes.
Commissioner Montemayor,
Yes.
Commissioner Topshin,
Aye.
Vice Chair Copeland,
Yes.
Chair Marks.
Yes, thank you very much. The motion passes. Moving right along to public comment. I will note that there's this new state law about public comments and virtual meetings in light of the continued COVID pandemic. If Mr. Secretary or Mr. Natalizia would like to give us a quick update on that, that would be very helpful, I think, because it's a little bit changed starting October 1st.
We're required to allow public comment throughout the meeting. So to meet that requirement in between the public comment periods, we can ask if there are any new public speakers at the beginning of each item, and I'll admit any speakers that enter the meeting in between items.
Great, thank you. Mr. Natalizia, is there anything to add?
No, Chair Martz, I just wanted to say that for this commission, this is generally not going to be a problem because some cities during the pandemic were only allowing written submissions, and then the secretary was, reading 3 minutes worth of public comments. But here, we've always allowed public comments to appear either virtually on the phone or through written submission. So it affects us less, but what Secretary Vidlon said is also correct.
Okay, so to be in compliance with the spirit of the law, we should be overly broad and generous with our public comments. And at the beginning of each manager's report, appeal, and new unfinished business, we should ask if there's public comments on those specific items.
Yeah, sure. I think that it's being overly cautious, but that's for us attorneys, we like that.
Yes. Okay, perfect. Everyone understand? Any questions on that? Excellent. Okay, thank you. Appreciate that. And going back to that, do we have any public speakers?
Not at this time.
Okay, great. We will move right along to the manager's report. Do we have any public comments about the manager's report?
None at this time.
Thank you. Mr. Holland, the floor is yours.
Thank you, Chair. Good evening, Vice Chair as well, Commissioners Jonathan Hollub, Rent Stabilization and Housing Manager. Taking a look at the look-ahead calendar, tonight we have one appeal. We'll also be having a presentation on the report from the Ad Hoc Committee on Valuation Guidelines. At the next meeting on October 28th, things change quickly, and that's actually going to be one appeal. And in December, there will be 2 at each meeting. So a little bit of a change to what's in front of you tonight. Also on the 28th, per the commission's request, Beth Zedek will be joining us for a presentation on the UD process. And at that time as well, I hope to have some statistics for the commission regarding the current volume of evictions that we know about in the city, primarily through Beth Zedek, although the division gets or should be getting summonses and complaints from landlords who are filing eviction proceedings. I don't think that's always the case, but Beth Zedek obviously knows the actual cases that are going forward that they get. Excuse me. I'd also like to mention for the public's benefit that on October 19th, there will be a building blocks webinar presented through the Rent Stabilization Housing Division. Then the 19th, it'll be landlord basics. And on the 26th of the month, it'll be landlord advanced. And if anyone is interested in our building blocks program, information about that can be found at the city's website. And if you go to the main page and just plug in building blocks into the search field, that's the best way to find that. In fact, that's the best way to find anything on the website quickly. Just type what you want into that search field. And that's all I have to report. If there are any questions for me, happy to take them at this time.
Commissioners, questions? Yes, Commissioner Ayers, and then Commissioner Kirkby to follow.
Thank you. Yeah, I was just wondering if the building blocks workshops or seminars or whatever they're called, if that's been promoted, publicized to the community, to the West Hollywood residents.
Yes, it is. It was promoted in our newsletter in July, and that goes to every rent stabilized tenant and the agent of every landlord in the city. It's also on our website, and when they come up, I'll mention them here as well. So we try to get the word out as much as possible.
Great. Commissioner Kirkby?
Yes, I just had a question about what is the penalty if a property owner does not submit notice to the city before eviction or during the eviction process?
I can't say for certain what every court does. It's my understanding that there could be a procedural defect. And I know that the division gets Public Record Act requests for those documents, and we indicate if we don't have it, and that's something that, or we get a subpoena. So my understanding is that, some courts will dismiss the UD if it wasn't done.
Thank you.
Commissioners, other questions? I see none. Mr. Holub, thank you very much for that. All right, moving right along to commissioner comments. Do commissioners have any comments at this time? Commissioner Kirkby?
Yeah, I just wanted to, I don't think the manager covered it this evening, so I'll go ahead and talk about the California COVID Relief Act. They are still accepting applications. You can receive 100% of past owed debt for rent for back to April 2020 and up to 3 months future rent. And this is both utilities and rent. So please go to housingiskey.com if see if you are eligible. If you make under 600, if you are under 80% area median income, which for one person is $66,250, and you were impacted by COVID-19 financially, you may apply or you may qualify. So please go to housingiskey.com to get this money. Thank you.
Thank you for that, Commissioner Kirkby. Other commissioner comments? All right, lively bunch. We will move on to our appeal. Mr. Secretary, do we have any public comments on the appeal?
No problem. Thank you. Sorry about that. Chair, no public comment at this time.
Okay, wonderful. Thank you. We are now at the appeal portion of the agenda tonight. It looks like we have one appeal. It is on D-4583. Mr. Secretary, do we have representatives for the tenant and the landlord tonight?
The tenant will not be attending, but we do have Areli Saeed representing the property management, and I'm admitting her now.
Okay, perfect. Okay, it looks like Areli Saeed has entered. Are you able to hear us?
Yes, I hear you.
Okay, perfect. And you're a representative for Apex Properties Hollywood LLC?
Yes.
Okay, thank you. So how this will work is we're going to hear a staff report from our legal counsel, and he will explain the legal portion of this matter. And then since we don't have the tenant present tonight, you will have 5 minutes to speak and to present your case. And then if the commissioners here have any questions for you, that will follow your 5-minute presentation. And then we will enter into deliberations on the matter. And once we go through the report, I will repeat these instructions for you. But once you begin speaking, you'll start with your name, your city of residence, and you will proceed with your comments as long as they are on topic and no new evidence can be introduced. All right?
No.
All right, perfect. So you can go ahead and go on mute. We're going to have our legal counsel give his presentation, and we'll be right back with you.
Okay. Perfect.
Mr. Natalizio, you are up.
Thank you, Chair and Vice Chair and Commissioners. My name is John Natalizio. I'm the legal counsel to the Rent Stabilization Commission for the City of West Hollywood. This appeal was filed by the landlord, which is Apex Properties Hollywood LLC, in response to a hearing examiner's decision granting a rent reduction application relating to the failure to maintain minimum maintenance standards. The tenant, Samuel Fibish, who resides at 932 Larrabee Street, Unit 208, sought a rent reduction for, at least relevant to this appeal, landlord's failure to repaint the building's exterior and replace the common area carpets within the requisite time frame in the rent stabilization ordinance, which I'll refer to as the RSO. A decision was issued on July 7th, 2021. And in that decision, the hearing examiner determined that the landlord had not performed the necessary maintenance in the time frame required in the RSO, and therefore granted a rent reduction of $23 for the common area carpets and $30 for the building exterior. So the landlord's appeal claims that the decision constitutes an abuse of discretion. And specifically, the landlord argues that even though it's been over the 7-year period, the exterior painting and the common area carpeting are in good shape. And landlord's appeal argues that the exterior of the building should have been inspected prior to the issuing of the decision. Staff wishes to address landlord's written submission to the commission. Landlord's written argument includes, in staff's opinion, new substantive matters that were not raised in the appeal. Landlord's appeal does not make any arguments that the hearing examiner failed to admit landlord's evidence, nor does landlord's appeal raise any due process violations. Regulation 60035 provides that matters not raised in the appeal are deemed final and therefore cannot be considered by the commission. And these last-minute substantive arguments are the exact reason why all matters being appealed must be included in the actual appeal and not in a written argument just days before the hearing. Further, Regulation 60018 requires the hearing examiner to retain all exhibits offered before or during the hearing. Not only are there no exhibits from the landlord in the file, the hearing examiner explicitly provides in the decision that no such evidence was submitted. The decision notes that no party submitted photographic evidence regarding the exterior building and that the landlord did not submit photos or other evidence regarding the common area carpets. Nowhere in the decision does it note that the hearing examiner denied the submission of evidence by landlord or that landlord even attempted to submit evidence. Further, there are no objections or written protests in the file from the landlord that such due process violations occurred. Landlord's appeal is merely based upon the argument that the building's exterior and common area carpets are in good shape, and therefore do not need to be maintenance in accordance with the RSO timeline. The only objection made in that appeal is that the exterior of the building should have been inspected. The allegations of due process violations should have been included in the appeal if they wanted those considered. Additionally, staff believes that the arguments presented in that written submission to the commission constitute new matters. Regulation 60032 provides that no new matter or evidence shall be received or considered unless it's shown why such matter or evidence could not with due diligence have been produced to the hearing officer. And so there's no reason why the landlord could not have objected to this alleged due process violation during the hearing, which would have been reflected in the decision as well as included in the case file. And certainly would have been included in the appeal application. So staff has reviewed the appeal record and recommends affirming the hearing examiner's decision. Staff believes there is substantial evidence supporting the hearing examiner's decision. The RSO imposes minimum maintenance standards for all rental units. If that minimum maintenance is not met, the RSO authorizes a corresponding rent adjustment. As it relates to the exterior painting, the RSO requires that a building's exterior must be painted once every 7 years. However, the RSO permits the hearing examiner or the commission to disregard this requirement if it is found the work is not necessary. This commission has held that the term necessary has a specific meaning in the context of minimum maintenance, and the commission has consistently held that work is not necessarily only if it is in a, quote, like new condition. Here, tenant established that the exterior of the building had not been painted since 2012. Landlord does not dispute this fact and actually acknowledges that the exterior has not been painted in over 7 years. Despite arguing the exterior paint is in good condition, there's no evidence submitted by landlord demonstrating the exterior of the building. The hearing examiner correctly relied upon the testimony of the parties to establish that the minimum maintenance standards have not been met, and the hearing examiner did not err by determining that landlord failed to establish its burden that the painting was not necessary. As relates to common area carpeting, the RSO requires that a building's common area carpeting must be replaced once every 7 years. As with the exterior paint, the RSO permits the hearing examiner or the commission to disregard this requirement if it is found that the work is not necessary. Again, here, tenant established that the new carpets have not been replaced since 2012. Tenant submitted a photo demonstrating the type of stains that are alleged to be common throughout the property. The fact that the carpets have not been replaced since 2012, again, is not disputed by landlord. The landlord in this case, again, believes that the carpets are in good condition, but as with the exterior painting, there were no photographic documents or other evidence submitted on behalf of landlord to demonstrate that. The landlord testified that the carpets are regularly cleaned, and therefore the replacements of the carpets are not necessary. However, the tenant disputes the frequency in which the cleaning occurs. Therefore, based upon the above, staff recommends adopting resolution RSC 21-601. You as the commission have the power to affirm, reverse, modify, or remand the appeal decision of the hearing examiner. The commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the commission to make sure there's substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, the decision must be upheld, even if there's also evidence that could support a different outcome. The commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. As it relates to questions of law, the commission applies an independent or de novo standard of review to the hearing examiner's conclusions of law. Thank you.
Great, thank you. Commissioners, do we have any questions? Commissioner Kerpes.
Thank you. Yeah, I just have a couple questions about, and you might have covered it in the due process, and just let me know if it falls into that. But the notification for a rent reduction hearing, or for the tenant must first submit a document to the landlord in writing saying, please fix X, Y, and Z, and then 30 days after that is when they can apply for the hearing. Does that apply for the external paint and common areas as well?
I believe any maintenance, anything that's relating to maintenance of the buildings requires that 30-day notice process. That's my understanding.
And do we know, I know it wasn't an issue, at least in the summary that the hearing examiner wrote up, it didn't seem to be an issue, but are we aware of whether the notice was provided for that? The only thing I can find in the file that mentions the external paint, other than the discussions during the hearing, is on the one page on the back side of the checklist for filing the hearing application on the back side. I see it listed there, but other than that, I don't see, unlike all the other items, I saw notes and emails discussing it, but I didn't notice anything like that. And I was just wondering if we knew, and if that was could play a part in later in this hearing if the landlord didn't have the opportunity to have brought up the evidence. I mean, I don't know what they can and can't argue now.
Sorry, so I guess so you're saying you don't see any sort of 30-day notice requirement from the tenant regarding the exterior painting?
Well, I thought it was odd that the landlord would say an inspection needed to be done, but yet they didn't bring any evidence to the hearing. So that's what made me start looking for, well, were they notified? And I just didn't see anything other than on the appeal hearing, or not on the appeal hearing, the hearing notification. I'm just curious if this is even relevant, first of all, or should this have been handled at the hearing if it were the case that they weren't notified?
Yeah, I mean, I think to answer the first part of the question, it would not be relevant just for the fact that that wasn't appealed. And if there was going to be a challenge for the 30-day notice, that would have been had to be at the hearing level. I guess I don't know off the top of my head everything that's in the appeal packet for the notice, but I remember at least reading in the decision something relating to the fact that the hearing examiner had found the 30-day notice was met. But to the extent of, I just can't remember off the top of my head if there is specific evidence in there.
It doesn't sound like it'd be relevant anyway, right? Is what you're saying?
Right, it would not be relevant, just because it's not appealed, and it would have, like you're saying, should have been addressed in the hearing.
All right, thank you.
Commissioner Maggio.
Yes, can you hear me? I'm having a problem.
Yes, you are on.
To legal counsel, since the only exhibit that I have in front of me is the carpet exhibit, which is pretty clear to me, but there was no photograph of the building, so I took it upon myself to drive by the building simply because the tenant the landlord had mentioned the color was in contest, and I don't think that was a problem driving by. Is that okay?
Yes, I will say that evidence the commission needs to consider should be only evidence presented during the hearing. It's fine that you disclose, I guess, for lack of a better term, an ex parte action taken on your part to look at the building exterior. I guess it'd be no different than if you looked on like a Google Maps of the property, but the basis for your decision has to be based upon the evidence presented during this hearing and not based upon your viewing of the building outside of this hearing. Does that make sense?
That clears it for me. Thank you.
Commissioner Ayers, do you have your hand up? No. Okay. Any other questions? No. Okay, perfect. Thank you, Mr. Natalizio, for the legal information. Moving on.
Sorry if I can interrupt. We have in the waiting room, I'm not sure if it's the other, another representative for the landlord, but the number ends in 4957. Should I admit this person at this time?
Yes, and we will find out who they are, please. All right. Phone number ending in 4957. You're on mute, but can you unmute and let us know what agenda item you're here for?
Hello, it's Pablo Alcina. I'm the resident manager at 932 Larrabee.
Okay, perfect. And Ms. Said, is this a party you're affiliated with? Okay. Which one of you will be speaking tonight?
I will be talking. Sorry, I had a complication at work, so I was just able to jump on now.
Certainly fine. All right. So I explained to Ms. Said, am I saying your name correctly? Okay, wonderful. Ms. Said, that since the tenant is not here, this will go a little differently than normal. You are the appellant, the person that filed the appeal. So you will have 5 uninterrupted minutes to speak, to state your case. You're going to state your name and your city of residence for the record. And then you will need to keep on topic, and you can only introduce evidence that was presented at the hearing or prior to that. No new evidence. All right.
Okay.
All right, perfect. Then you have 5 uninterrupted minutes starting now.
Yes, I'm the resident manager at 932 Larrabee. When the tenant filed the complaint to our building about the carpets and all that, it was in the middle of the pandemic. We always clean those carpets on schedule. The building is always extremely well maintained. During COVID, it made that a little bit difficult to have people come out, but our building has still been in great shape. The carpets to me look good and look always looked better when we were able to maintain them regularly. With the pandemic and all that kind of delayed it, which made it get a little worse. Also, tenants were home a lot more than usual because nobody was working. So that made the carpet stains look a little bit worse than they would normally be. But again, that was totally because of the pandemic. The rest of the building is in great shape. We submitted photos where you can see what the carpets look like now. You can see what the building looks like. You can see the lounge we have set up. You can see the pool. It's a beautiful building. I've lived there for the last 4.5 years. I'd say almost everybody that I've spoken to, nobody had ever complained about how the building has been run or how it looks until we got these complaints from that one tenant. And again, everything he's asked for, we painted his unit. We gave him new carpets. Now he said again that he wanted his bathroom painted, and we painted that as well. So I mean, Rio is an amazing management company. They've done everything that we've needed to do. And ever since I've managed the place, and even before that with the previous manager, the building has always ran smoothly. Right now we're at full capacity. And again, I believe the carpets and everything that they were complaining about, I don't think their complaints hold water. It's just everything looks good. There's lots of elderly patients that we have in this building, so none of them have complained about carpets. I think the carpets look good. If we're forced to put in floors, then I think the noise level of people, if they're running or whatever, would be louder than with carpets. Again, I don't think they're needed. And the paints on the wall have always looked good. You can go by our building now. And again, if there was any at all delay was to cleaning carpets or taking care of the building, due 100% to a pandemic situation that we were in. We also have tenants that haven't paid at all, and we still keep going forward and really running that building how it should be run. We have 2 on-site resident managers that are always available 24/7. People, we tell them to call us from 9 to 5, but we're always there. When people log their keys out, we're always there. One of us is always there. I think we've done a great job. I think Rio has done an amazing job, and I totally do not agree at all with the complaints and everything that they're saying. I also think we keep the building smoothly, and all the tenants are relatively, to my knowledge, have been happy with the building. We have not had complaints at all until this. And I don't know what else I can say except that I've truly enjoyed living in that building, truly enjoyed being a part of Rio, and we do our part, and I work hard, and my wife works extremely hard to keep our tenants happy, to keep the building running smoothly, and I think we've done that for close to 5 years now, even during a pandemic.
Right, perfect. Thank you. I appreciate that. Commissioners, do you have any questions for him? I do not see any. No? Okay. Mr. Alcina, you can go on mute. We are going to deliberate on this matter now. Thank you. All right. Commissioners, who would like to go first? Mr. Maggio, I think I saw your hand flash.
Can you hear me? Because I'm having trouble with my audio.
Yes, you are excellent.
Well, it's very interesting. The exhibit that is shown in front of us in relationship to the carpet shows that the carpet seems to be old and dirty, and that it's due to be changed because of the rent stabilization ordinance of changing every 4 years. However, the commission has held that the term necessary has specific meaning in the context of minimum maintenance. And the commission has consistently held that work is not necessary only if it is in like new condition. And I think I'm really referring to the painting of the building. The tenant, of course, has said that the building has not been painted since 2012, and the landlord has not disputed that. But I have no photographs or anything in front of me, no exhibits to show me whether the building looks like it needs to be painted or that the paint is chipping off. So that remains to be a problem, and I think of it as really incomplete. Thank you.
All right, further, yes, Commissioner Topshin.
Thank you, Chair. Just
Did we lose Commissioner Topshin?
We did at this end.
Okay.
I'll be
all
quick.
right.
What establishing? Can you hear me?
Partially. Partially.
That's
Okay.
interesting. There was a problem with the connection up until now.
Okay, I think you're here.
All right. So,
Go ahead.
yeah, I'll try to be quick then. It is important to understand that while the burden of establishing the violation of the RSO has occurred falls on the tenant. And in that case, the landlord will have the burden of establishing that the work is not necessary, is not needed. And that's what that's how we ruled in every other case that we had with a similar, obviously, facts. So now Commissioner Maggio specifically mentioned that we only when we would vote against the rent reduction if it's the service is in like new condition. And that is very important to understand. Here, the landlord basically did not provide any evidence that would show the work was not necessary. It was just the argument that the paint is in good condition, the carpet is in good condition. So, but that is not enough. That doesn't satisfy the requirement under the rent stabilization ordinance. And therefore, the decision was not in error, the decision of the hearing examiner that granted the rent decrease. So that's what I wanted to say is that, and there is no, it's undisputed that both services they haven't been replaced since 2012, which is over 7 years period. So I have no issues of affirming this decision of the hearing examiner in this matter. Thank you.
Thank you, Commissioner Topshin. Further comments from commissioners? Commissioner Kerpes, Commissioner Ayers, and then Vice Chair Copeland.
Yeah, I'll just make mine quick. I agree with the statements that have been made that our ordinance is very clear on the length of time that carpets need to be replaced, and same with the building painting, exterior painting. The exterior painting, there was no evidence other than both sides agreeing what year it was, which is clearly beyond the 7-year mark, and without any evidence of the contrary, that the building would be like new, the paint would be like new, which I have to say, it's very rare that I've never seen it in the years that I've been on the commission where someone has been able to provide the evidence to show that it was like new. I think maybe one time with carpet, but we were talking about a case where it would had been covered with basically wrapping for several years. So I don't really think that you could have prevailed on this issue. The landlord could have prevailed on this issue, but that I have no problem with moving forward with the staff recommendation upholding the hearing examiner on these two issues.
Thank you for that. Commissioner Kerpes, Commissioner Ayers.
Yes, I'm inclined to support the hearing examiner's decision in both cases as well. I believe that it is, I guess the onus is on the tenant to show that the exterior painting is needed, but the landlord did state that it was in good condition. Good condition isn't excellent condition. It isn't like new condition. And because it should have been done by 2019, I would say that it is due for an exterior painting with the common area carpeting. I saw the tenant's submission of evidence of pictures of the carpeting and found that, the carpeting definitely is not like new. So I'm inclined to support the hearing examiner's decisions on both. Thank you.
Thank you for those comments, Vice Chair Copeland.
Yeah, I will echo some of those comments. I noticed on the appeal filing paperwork, it says the painting and carpet of the building's exterior is in good shape, even though it's over the 7-year requirement. It's actually almost 10 years now, at least. And the burden of proof was on the landlord at the hearing to show that it was in like new condition, if that was the case with either of those issues. Obviously, we've seen with the carpet, it is not. Certainly, if those issues have been remedied, the landlord can apply for a compliance determination. But I didn't hear anything about the carpet. I believe he mentioned something that some painting and other things had been done. But I would be in favor of affirming the hearing examiner's decision as well. I think the evidence was there, and the ordinance is very clear about maintenance standards and what the one exception would be, like new condition, and that's not been the case proven here. So thank you.
Great. Thank you for those comments. Commissioner Montemayor, I saw your hand go up.
Thank you. I agree with my colleagues. I'm comfortable with affirming I'm comfortable with staff's recommendation with affirming the hearing examiner's decision. I think the RSO is incredibly clear on the timeline for improvements, whether it be carpeting, painting, or otherwise. So for me, this is a very clear and easy decision.
Great, thank you. I believe I'm the last. I will not take a lot of time. I concur with everyone's points. The hearing examiner made his decision with the evidence that he had. It was not bountiful, but it was sufficient enough to meet the requirements of the RSO and due process. And unfortunately, the landlord did not provide anything to rebut that, photos or documentation that would say it was newer or whatnot. So I believe that the staff's recommendation is correct here. I do want to note that I appreciate the landlord's good work that they have stated that they've done. It's just we have pretty strict requirements in West Hollywood with dates to or years to replace certain items, and it's very rare that those can be avoided unless you take pristine care of the properties. And those are maintenance standards set by the city that we uphold at the Rent Stabilization Commission. But I do appreciate the words that you put forth to us today. I would entertain a motion if anyone would like to make one. Yes, Commissioner Ayers.
I'll make a motion that the commission adopt resolution RSC 21-601, a resolution of the Rent Stabilization Commission of the City of West Hollywood affirming the hearing examiner's decision as to application number D-4583.
Thank you. Second?
A second.
We have a motion and a second. May we have a roll call, please?
Commissioner Ayers,
Aye.
Commissioner Kirkes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Montemayor,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Copeland,
Aye.
Chair Marks.
Aye. Thank you. The motion passes. The parties are going to be placed back in the waiting room. Thank you for attending the appeal tonight. If you do have any questions, you can contact the Rent Stabilization Commission. They're available by email at rsh@weho.org. Again, rsh@weho.org, or by phone at 323-848-6450. Thank you. All right, moving on to new and unfinished business. Mr. Secretary, any public comment on that section?
Not at this time.
Thank you. Mr. Holub, you have the floor.
Thank you, Chair. Good evening again, Commissioners. Again, Jonathan Holub, Rent Stabilization and Housing Manager. At this time, staff is going to present the report from the Ad Hoc Committee on Valuation Guidelines. I'm going to pull up a PowerPoint, give a brief summary of the report. Be with you in just a sec. Okay. All right. Chair, are you receiving?
Yes, I see that.
Okay, great, thanks. All right, so this is the report from the Ad Hoc Committee on Valuation Guidelines. This is sort of the background on how this came to be, the establishment, purpose, and engagement on it. The Ad Hoc Committee was established by the Commission at its meeting on March 25th of this year. The members were Vice Chair Copeland, Commissioner Topshin, and Commissioner Ayers. They were tasked with reviewing the valuation guidelines and making recommendations to the full Commission. The committee convened on 7 occasions with staff. There were also frequent conversations with staff, and ultimately the committee concluded that the revisions to the guidelines and attendant regulations are warranted. The current valuation guidelines were introduced in 2001 to assist the hearing examiners and the Commission with establishing appropriate values for reduced or eliminated housing services. The guidelines are just that. They were not intended to be absolute or determinative of value, but to be used along with regulations governing housing service valuation. Some additions to the list and a CPI increase happened in 2014 following the report from an ad hoc committee review that occurred at that time. These are the recommendations from the committee regarding the valuation guideline and how they should be adjusted. There should be increased values at a minimum by the AGA since the last adjustment in 2014. The committee included additional housing services, and all of this is at Exhibit B of the report. No minimum less than $5 at the low end of the range. The range should be minimally consistent with the range between average low and high end of rents in the city. So the spread, so to speak, between the averages in the city should be reflected at a minimum in the range that you see in the valuation guidelines. The committee also adjusted them consistent with factors such as impact of the loss on habitability and or quality of life. So some were weighted more heavily than others. Also, they were adjusted consistent with other jurisdictions' best practices. As you may recall from the initial presentation and formation of the committee and the report that's included at Exhibit A, other jurisdictions have different valuations, and we also looked at those. The recommendation as well is to ultimately, should the commission move forward with the recommendations and new guidelines be promulgated, that they be adjusted annually by the AGA. This is the current valuation regulation. It's in regulation 60041B, and it requires that the hearing examiner or the commission evaluate the amount of rent decrease that may be reasonably compensated to the tenant. They should consider to the extent to which the reduction in services affects the tenants of a given rental unit, the relative significance of reduced service in relation to safety, health, convenience, and comfort of the tenants, the prevailing market value of the housing service in question as a rental amenity, the extent to which the tenants were led to rely upon the fact that the service would be provided, and such other factors as are deemed to be relevant by the hearing examiner or commission. The committee was generally satisfied with this regulation, but also recommends amendments. And the recommended valuation regulation amendments are as follows: to require consideration of valuation proportional to rent, which is consistent with other jurisdictions' best practice. Base certain valuations on loss of square footage, depending on what the housing service is. Consider for certain items the actual monthly charges of lost services. For an example that's used in the report is internet. The committee recommends a specific amendment that states that no mitigation of value for the loss of the service due to code or insurance compliance. The committee also recommends integrating these guidelines into the regulations. Currently, they are a standalone form. And also to specify that while they're integrated into the regulations, they in and of themselves are not determinative, and that each case is unique. So I'd personally like to thank the committee for all their hard work on this. And if there are any questions, I'd be happy to take them at this time. Thank you.
Commissioners, any questions? Commissioner Kerpes.
I have a question. First of all, thank you for all the work on this committee and going through these as thoroughly as you did. This was a much bigger report than what I was imagining we would get. I figured we'd just get a new updated guidelines or an updated list of pricings. So it's great that you did this. The question I have is, Mr. Holub, on the manage or on the slide that you had the current regulation up, that is the current one, right? Under existing law?
Yes.
And so what would we be changing in that that would incorporate, because I read that as incorporating most of these already, the how to determine the values.
Well, in terms of the actual substantive issues in there, there is nothing specific as to prohibiting a mitigation of a value for code compliance or insurance compliance. And in past commission decisions, the provision on considering health and safety has been used as opposed to, in a manner not to necessarily increase the value, but to decrease the value, because the hearing examiner of the commission has considered a code compliance action or an insurance compliance action as increasing the health or safety of the tenant and thereby warranting mitigation of the valuation or lowering the valuation of the decrease. The committee felt that that was not the actual purpose behind that provision, that provision was intended to, if anything, go up from the baseline, and that the tenants who are losing the service and shouldn't be effectively penalized because the landlord had an illegal or unsafe housing service that they had presumably rented their unit because it existed. So that's one thing. The issue of, since they're going to go into the proposals that the guidelines go into the regulations now, it becomes particularly important to indicate to the hearing examiner and this commission and future commissions, if you should decide to go in that direction, that it's not determinative, that they are guidelines only, and are there to help and be part of the process of determining what the valuations are. The other thing that's not in there, which is in other jurisdictions, is specifically looking at what the rent of a particular applicant is, so that if, for example, you have a very far long-term, very below market tenant, that the valuation for that particular tenant may be different than someone who just got a unit and is paying 3 times as much, because it presumably the housing service value is different in someone who is paying a different rent. And that's not an unusual practice in other jurisdictions, and currently is not specifically indicated. Let's see, what else? The square footage issue. That's precedent among the hearing examiner and commission in some cases has been to actually calculate a valuation based on loss of square footage, for example, a shed or loss of space. Actually, I think there was a case where it was a code compliance issue where there was a illegal addition and that had to be legalized and removed, and the tenant lost their space. So the hearing examiner, I'm not sure if it went up on appeal, but the hearing examiner calculated it based on the, as a portion of the rent. Let's see.
One more prohibition or something.
Actual cost of the actual cost of a housing service. Some of these things would have possibly been considered based on the current regulation, but they're not spelled out. And the committee was concerned that because it's not clear, that there can be more of a variety of determinations than is desirable, and that in certain situations for particular housing services, the best way to value it is to just look at what it actually costs on a monthly basis. So it's true that the existing regulation, like I mentioned, the committee was, generally satisfied with what's there, but there are gaps in the committee's opinion that should be clarified. And if I missed anything there, let me know and I'll talk about it.
Could you provide maybe like a practical example of the how it would work for the various rents? So you coupling it with the service with the rent. So they might be identical air conditioners, but the person in the lower rent unit is going to see a difference for the removal of that service than somebody in a higher rented apartment.
Right.
Right.
Yeah, that would be the proposal to specifically look at that factor, which, as I mentioned, is something that is commonly done in other jurisdictions. And I think the way to illustrate that is, the rent represents a bundle of goods, so to speak, and the values that you can ascribe to a air conditioner, for example, in someone who's paying $600 a month is necessarily going to be different than someone who's paying $4,000 a month. If you always went with the same figure, you might not get a reasonable result in both cases, because even though there's no fixed figure for setting these valuations, and no fixed formula, it still has to be reasonable. This would be something that the committee thinks the hearing examiner should consider when valuing an individual unit item.
And if we have any examples in the past where that has been an issue, where we were not able to figure out the value, or we had difficulties figuring out the value of something based upon the individual's rent?
I'm not aware of that, but as if the commission moves forward with the valuations that are new and are in some cases an increase of significance, then it could. So I'm not aware of a specific case where that's come up here, but one of the reasons that the commission wanted to look at this was because it felt that, and this is the committee's opinion as well, that that West Hollywood is a bit out of sync. So they want to get it more aligned with the more common practice.
Thank you. That's all of the questions I have. I do have several comments, but I'll wait to hear what other people have.
Commissioner Maggio.
Yes, Jonathan, I have 3 questions. One on the smoke detectors, the lower number at 22, the higher at 60, would that indicate more than one detector? And storage, the lower number would be for a smaller storage space, and the larger, I would imagine, would be for a larger. And how is that determined? I think you kind of mentioned square footage, and how do we determine that? The third would be vermin infestation from 41 to 175. Vermins are vermins. Does that mean more or less? I really don't understand that one.
Okay, I think it's important. Well, first of all, with respect to smoke detectors, I think the intent there is individual smoke detectors. So if there were 4 smoke detectors that were required in the property and 4 were missing, then it would probably be each. So that can be added because I know that on some of these things there it says per thing. But I think it's important to just keep in mind in general. I'm hesitant to. Well, say this about the valuations. Again, they're a range and they're just guidance. So with the storage, for example, whether that would be on the lower end because of the size of the storage unit or be on the lower end because of the actual rent paid by the tenant or because of how important it was to the tenant or because of the quality of the storage space itself, those are all things that the hearing examiner has to take into consideration. And the guidelines have always just been there to provide a framework, maybe a starting point is a good way to look at it, and then to analyze it on a case-specific basis, either under the current regulations or if the commission moves forward with adopting new regulations under those regulations to arrive at a figure that's appropriate for that specific case. So, and storage is a good example for why the other proposed amendment might be appropriate, that in some cases it might be more appropriate just to simply look at the square footage that was lost and to make a determination based on lost square footage, which could fall within this range or might fall outside of it. And I think and vermin, I'm sorry, what was the question about vermin?
Well, how would you determine that? Is there 1 rat in the building or 10 rats in the building? I don't know how else to put it.
Right. And that's exactly the point, that these are not the final say. There's cases where there's vermin and cockroaches in urban areas are a fact of life, and it might not be a code violation or represent a reduction in service. But then there is somewhere there's the point at which it becomes a problem, and then there's a continuum, from this is, a code violation, but it's an occasional rat or whatever, up to a serious rodent infestation. And that again is what the even under current regulations and current guidelines, what the hearing examiner should be looking at when they're making their determination. How bad is it? What's the loss? How much is it impacting the health, safety, and comfort of the tenant? And those things are what they're taking into consideration. So I don't think it's necessary for that particular guideline to quantify rodents. It wouldn't, I think, add any value to that number.
But I think what you're also saying, that if the problem is a larger problem, then obviously it's going to get a larger amount of decrease. For instance, if it took 2 weeks instead of 1 week, or 4 weeks instead of 2 weeks to eliminate the problem. Would that be correct?
Yeah, in terms of the time it existed, perhaps, or how long it's been going on, how bad it is, what the vermin is, how it eliminates the tenant's ability to use the unit. I think those are all the kinds of factors that the hearing examiner should be considering when determining evaluation.
And the other question I had about oven and stoves, I mean, if an oven doesn't work, it doesn't work. So how could an oven be less or more?
Well, actually, we've had cases where they work somewhat, but are still considered well, first of all, as you know, the code requires that a landlord maintain appliances in good repair. So there have been cases I recall where one burner isn't working, for example, and a reduction has been awarded. So it's still not as problematic as all burners not working, or the oven works, but the stovetop doesn't work. And so there's situations where actually that I recall where, it's not as bad as a complete loss. But if it were a complete loss, then the valuation should go up.
Thank you very much for answering the questions.
You're welcome.
Commissioners, other questions? All right, Commissioner Kerpes, you had comments?
Yeah, and I'll state my comments, and then I do really want to hear from the committee members too, to hear what you're thinking is behind some of these. So I think I don't have any issues with any of them. I think that a lot of these recommendations make sense. They've been issues that we've dealt with in the past, and or they've come in front of us in the past, and some clarification would be helpful to the hearing examiner. What concerns me is, though, that when we get down to the fifth one, amendment to the regulation that would specifically sets forth the removal of a housing service due to the landlord's need to make the property code compliant or comply with insurance requirements should not impact the valuation of the lost housing service. I think that there's a misunderstanding of what the problem is that we have faced in several appeals over the past several years. And the problem, I would identify the problem is that the hearing examiner may sometimes determine that the fact that it's been removed for a safety reason or for insurance requirements, code compliance, eliminates the consideration of it. Even it makes it determinate upon whether to even decide whether it is a housing service or not. There's never been, the commission has never taken issue. Once we've all decided that yes, it is still a service that is removed, we've never haggled over the price in terms of whether it was legal or illegal. That the issue has always come up of whether it was legal or illegal in the hearing examiner's role of determining whether he should even put a value on it or just dismiss it as, sorry, that's a loss. Everyone loses there. So I'm just hesitant because I think that over the years, the regulations as written have been fairly good. We haven't had any major problems. I don't know how it ends up in the courts, what those outcomes are. But I just don't feel very comfortable about changing what is a very broad, flexible regulation right now, how it's worded. I think that we could change that fourth one or that fifth one and make it so that it reads something to the effect of like, or comply with insurance requirements is not determinant or does not determine the loss of a housing service, or cannot be, that loss of a housing service is not determinant upon whether it is a removed legally because of code compliance or not. Because I do think that the value is affected by whether it's illegal or legal, safe or unsafe. Oftentimes the code compliance issue will remove a parking spot because it doesn't fit the regulations. So that to me would tell me that that parking spot is not the same value as a legal parking spot, because they always had a smaller spot than the other one. I think if we take too much out of the hands of the hearing examiner, we will see more problems and not less. And I think that you guys did an excellent job. I agree with all the other issues. I mean, I'm kind of confused. I'm going back and forth on the price of comparing the service with the price of the rental. That I don't think is fair to the property owner, because it leads them, it makes it even more, I don't know. I go back and forth, and I'm trying to look that one over. It's just, I don't know if we want to do that with number 5. Thank you. But I'd love to hear what your thinking is.
Commissioners who are on the ad hoc committee, do you want to share a few thoughts? Yes, Commissioner Topshin.
Thank you, Chair. First of all, I really want to thank Manager Holub and staff, the Rent Stabilization Division, everyone who was involved in putting together this report. This is incredible, the work that we did as a team. Staff and Manager Holub, they were very open and accessible, and very open to our ideas, and obviously committee members, can speak for themselves, but this is my opinion, and I'm very pleased that every time we would call or email, they would receive a positive response, and that was very, very different from what we had in the past. And I just wanted to say it, for the record. Thank you very much. And this is a wonderful report, very complete, that shows and presents every aspect of our discussions and deliberations that we had during the committee and have committee meetings. So now I just wanted to maybe in response to Commissioner Purpose's comments regarding number 5, just wanted to bring an example maybe, and maybe a hypothetical, although we had cases that I could remind, maybe Commissioner Purpose may remember those cases. I don't clearly remember each and every detail, but let's say it could be in a hypothetical scenario why this number 5, the ad hoc committee believes that should be there. We had years ago, we had cases. In one particular case, I recall that one particular case when the tenant lost the service of a huge rooftop patio. It was a large area for the tenant's exclusive use. The tenants, I don't remember whether living room or bedroom was connected to that top roof patio. The tenant enjoyed for years. I can't remember what was the rent the tenant paid, but it was at the time it was relatively close to the market rate. Let's say a market rate. Let's just set a $2,500 rent. We didn't have the guidelines, the section of the guidelines we have now, which is 641B, A and B. We didn't have it at the time, so the examiner looked into it and said, okay, this patio was cited by both the landlord's insurance agency and also the code compliance. So this is not a service. So this has to go. And then we're gonna give a nominal $1 rent decrease for the service. So the tenant appealed that decision, and we didn't have anything to support the appeal, to support the tenant's basically assertion that this was a service, because when the tenant looked for that apartment to rent, it was stated by the tenant, was established basically by the tenant. The tenant established the RSO violation, that this was the main reason why he rented this place and paid $2,500 monthly rent, because this exclusive patio, rooftop patio that the tenant had, which was obviously would basically make the unit the luxury unit. So that's why the landlord charged top dollar amount for that. And landlord benefited by charging more rent than the comparable unit in the building without the same service. So the tenant, it wasn't the tenant's fault that the landlord, prior to him renting, illegally created a patio there, because the landlord's intent was clearly to charge more rent to benefit from it. So clearly it wasn't the tenant's fault, and the tenant paid more rent for it. And when the time came for the landlord to reduce the service, to remove the service, which clearly had to remove the service because of the safety concerns, and there's no dispute and the question about it. But the city said it's going to be only a $1, not the city, the committee examiner determined only $1 nominal rent decrease, which is not adequate to the loss of the service, which didn't really represent the value of a patio, should that patio be a legal patio there. So that's why this, and there are other jurisdictions who have these similar protections, or I wouldn't say protections or categories as a determining factor in their regulations, that if the service is removed per the order of the department, the code compliance or the insurance, it should not affect the tenants. That should affect the tenant's rent, because the tenant's service, it's a substantial reduction in the service, so that it should be given a reasonable rent reduction, not just a nominal rent reduction. So we've had a couple of, at least I can recall a couple of cases, one with this patio, another one was a balcony. We thought that would be reasonable to add this to, in case this type of appeals will be filed. First, the examiner will have a different approach if this is in the regulations. So we will not even have probably a case appeal to us. Because the examiner will, from the beginning, determine this is a housing service and there was a substantial reduction. So there wouldn't be a so-called nominal rent decrease. So there would be a full force of rent reduction used. So, but if it comes before us, then we can consider this a housing service that affected the tenant's quality of life, and that should be an adequate corresponding rent reduction given versus the nominal. So that's one of the cases that I remember. I recall. I can remind it to you, Commissioner Kirpis.
Thank you, Commissioner Topshin. Commissioner Kirpis.
Yeah, and I think that I don't remember that specific case, but I remember variations of cases like that for sure. And I've always been, and I agree with you that this is a housing service. Those cases that I'm thinking of, and that the case that you just cited. I guess my point is that we're mixing those two issues together: the value and the service. And the hearing examiner has to first decide that a service was lost before they can set a value to it. So I'm just saying that we need to make clear that the hearing examiner cannot dismiss a reduction, or cannot dismiss something as a housing service just because it was removed by the insurance company or a requirement of the code compliance and like that. That's all I'm asking. But the valuation determination comes later, after the determination whether it's a housing service or not. So I think we're on the right track to advise the hearing examiner that he or she should not allow for the decision of whether it's a housing service or not be dependent upon whether it's a legal or illegal service or use. That's all I'm asking. How it's worded here is saying that the hearing examiner cannot consider that when placing a value on it. And I don't think that we should do that, because that one has not been a problem in the past, that part of it. Our problem has usually been when the hearing examiner doesn't place or says it's not a housing service. And then we say, yes, it is, and then we put a value on it. I just think that we're tying the hands of the hearing examiner, and it may not lead to the direction we want it to go if we don't let them figure out what the value it is. But I think that we do need to direct them that should not be, sorry, I don't know what this noise is in my house. But I think we should direct them that they should not let that influence our decision on whether it's a housing service or not reduction. That's all.
Well, let me clarify real quick. Commissioner Topshin, did you say that we have had cases where the valuation was reduced because either an insurance requirement was brought up or a code compliance issue was brought up, and they said it's not necessarily the landlord's fault as much because of one of those two issues, so we're going to put it at the very low value? Is that paraphrasing?
That is correct, Chair Martz, and we had cases, and and that's how the examiner ruled, and we really, our hands were tied at the appeal process because there was nothing to support in the regulations, an argument that we could have made at the time that it is irrelevant whether the service was illegal or not. That's the service was rented to the tenant, and the landlord put a rate, a market rate on that service when the landlord offered for rent. So if anything, that's not the tenant's fault. It's the landlord's wrongdoing. So by the landlord benefited from it. Now we are, by not giving the adequate corresponding rent reduction or not putting a adequate value for that service just because it was created illegally, we're basically penalizing in a way the tenant. The tenant continues to pay the high rent without having that very important service. So that's why it is really, it's kind of the philosophy we need to understand is that it is irrelevant for the determination of the value, whether the service was legally created or not. It is absolutely irrelevant to the fact that the tenant rented, paid the market rent, and now he lost the service, he or she lost the service, is entitled to get the rent decreased. So that is the idea behind this. And by having, we have to acknowledge it. We have to acknowledge it in order for the examiner to be able to use the guidelines as the service would have been the legal service. Otherwise, if we say, okay, so this the fact whether it was created legally or illegally should affect the determination on the value, but it shouldn't really, because it's irrelevant, because the tenant doesn't really know when the tenant rents the unit whether this service is legal or not. So that's the idea. Thank you.
All right. Thank you for that. Commissioner Kirby, is any follow-ups to that or any other commissioners who have comments? All right, we'll go to Commissioner Maggio.
I would like to thank the subcommittee for the wonderful job they did. It's a lot of thinking, it's a lot of work. And as we go on, we will perfect all of this even more and more. But I think it's really a good start, and I'm happy we have accomplished this. Thank you.
Commissioner Montemayor.
I too would like to thank all the committee members for their work. It is a lot of work that you all did, and this is very thorough. As a new commissioner and someone who doesn't have the years of experience as some of my colleagues do, I appreciate the conversation that you're all having, and especially become reflective upon Commissioner Kirby's comments, because I do see his point. It's an important point. So I, just for the purposes of this discussion, would be amenable to his direction, which I think is still in the same direction as is what the committee is seeking to accomplish. I just think it provides a little bit more flexibility.
Vice Chair Copeland.
Hi, yeah, I was sort of thinking the same thing. If I'm not misunderstanding, maybe this should be expanded upon a little bit to include the wording that whether a service was, an initial service was found to be illegal or violation of code. And so maybe expand on it a little bit, because I think we had a case recently with rooftop access and use. And so that did come up. Other issues have come up, I know, over the years about code violations, and I don't think the tenant should be penalized because something that was added to the unit is illegal, or it's not been fixed and it's a code violation. Therefore, let's give them $1. But I certainly would be amenable to maybe clarifying or expanding on that a little bit more after hearing Commissioner Kirby's comments. And thank all of you very much for your comments and questions. And it's been a privilege to work on this and a learning experience. And definitely want to thank staff and our manager he's been so patient. Everything that we throw at him, and every idea, whether it's good or not, he's always open to it, and it makes things a lot easier. So I appreciate that. Thank you.
Thank you for those comments. Further comments? I will happily jump in. So I will echo all of these comments. Staff has put together a wonderful report here. The Ad Hoc Committee has done great work, and I think it touched on a lot of the concerns that we've had over years and months, and for some of you, decades probably, of concerns with these guidelines that are used by our hearing examiner. I am especially excited that it's going to hopefully be adjusted annually with the annual general adjustment. I think sometimes it's a little bit of a slap in the face to give our tenants $3 for something that they've waited through the pandemic 12 months to get here, and then we give them half a cup of coffee worth of rent adjustment. So I think that will have a big impact, and it's in line with what our goals are, which are to protect our rent stabilized housing and to give everyone a fair shot at what they're due under our rent ordinances. I think Commissioner Kirby's point is well taken, that we need to go along with not only the value, but whether it's a service or not, and whether it's lost or not. And Vice Chair Copeland makes good points that we should not be penalizing tenants for the errors of the landlord if they add something that's in violation of code or law. So I think everyone's done a phenomenal job, and I will close my comments there. Do we have any other comments to make? I see one. Commissioner Kirby's slide.
So are we? So are we voting on anything? Or are we just giving direction to staff? And if we are doing either of those, which I think we're probably doing at least one, do we want to reach some sort of consensus on that fifth one in terms of kind of direction of? I mean, I by no means am I trying to intentionally devalue whatever service that might be taken away. But what I'm saying is that we shouldn't place that burden. I mean, the hearing examiner has a role to play, and we just need to make it clear that they cannot disregard it because it's not a legally compliant service. That's all I'm asking. But do we need some clarity, Mr. Holland?
Well, if I'm understanding the consensus, as I understand it, is that the recommendation, generally the recommendations is presented, or the direction the commission wants to go, and with the addition to the fifth bullet point in the recommendations, that the hearing examiner or the commission cannot dismiss a something that would otherwise be a housing service simply because it is a code violation that's been corrected, or an insurance requirement that's been met. So essentially everything that's here with the addition of that language. And if that's the consensus, that's all staff needs to come back with a regulation and the new guidelines for the commission to vote on. The only thing we would need a motion on is a motion to dissolve the committee. And I spoke over myself. So is that the consensus of the commission?
Anyone disagree with that? We'll go that route. Okay, I see everyone agreeing that Mr. Hollob's analysis and summary was correct. Yes, Mr. Maggio, go ahead.
Don't we first have to accept and file the report and then we dissolve the committee?
Sure, I think that is effective.
All right, and does anyone want to, do we need to make a motion for those?
One could make a motion to file the report and everyone says no or yes.
And then do we need to do the same to dissolve the committee?
Yes.
Okay, who would like to make that motion?
I'd make a motion to accept and file the report.
I'll second.
May we have a roll call, please?
Commissioner Ayers,
Aye.
Commissioner Kirby's,
Aye.
Commissioner Maggio,
Aye.
Commissioner Montemayor,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Copeland,
Aye.
Chair Marks.
Aye, thank you. The motion passes. And the next matter, a motion.
Make a motion to dissolve the subcommittee on valuations and guidelines.
Second.
We have a motion and a second. A roll call, please.
Commissioner Ayers,
Aye.
Commissioner Kirby's,
Sure, they want to.
Commissioner Maggio,
Aye.
Commissioner Montemayor,
Aye.
Commissioner Topshin,
Aye.
Vice Chair Copeland,
Aye.
Chair Marks.
Aye, thank you. The motion passes. Again, thank you everyone on the subcommittee and staff for that hard work. I know that was a lot and you did a great job. Okay, so that is unfinished business. Moving on to item 11, items from staff. Do we have any items from staff?
I would like to thank Commissioner Kirpies for bringing up housing is key. It's amazing that I didn't say it. I think because I say it all day, it's absolutely critical that if you're a tenant in arrears that you apply for the program. And that's what staff is telling anyone who calls us. And if you do need legal assistance, Betzetic, as I mentioned earlier in the meeting, offers free legal counsel to tenants who are facing unlawful detainers in the city of West Hollywood. So information to contact them is available through our website. If you go to the coronavirus banner at the website and click on Renter Resources, of course, you can always call the division if you have any questions, if you received a notice, if you're concerned you're going to receive a notice, any questions whatsoever about the end of the eviction moratorium, what protections are still in place, staff is there to assist. rsh@weho.org or 323-848-6450. Thank you.
Thank you. Moving on to public comment. Mr. Secretary, do we have any speakers that have joined?
We do not.
Okay, thank you. Moving on to items from commissioners. Any additional comments from my fellow commissioners this evening? Commissioner Kirpies.
I should have brought it up at the very beginning, but is everyone going to be present at the December 23rd meeting? I think Manager Holub mentioned something about 2 appeals at each of those meetings, or did I understand that correctly? It was going to be 2 at each of the December meetings?
Right now, that's the way it's looking, yes. And I know that is right before, it's a good point, it's right before the holiday, so it's a good question to ask if we'll have a quorum.
Is it too late to move those 2 that would be on the 23rd? Would it be too late to move those sooner?
It's a manpower, it's a person power issue. We just can't accommodate as many appeals at a given meeting, and we don't have any November meetings is part of the problem too. And I don't think we can do 4 in one meeting. So we all eventually want to go home, but well, leave whatever seat we're sitting at. But to answer your question, it looks like that's the only way we can schedule it if that meeting happens. Obviously, if we don't have a quorum for the 23rd, then we'll push those to January.
Is it possible you notify us if those two, I mean, it might be the parties in the case might need to postpone because of that date. If that should happen on both of them, could you notify us? And then that might change our own plans on whether we wanted to attend the meeting without an appeal.
That's a great idea. I'll have staff reach out and I'll let you know at the next meeting what the schedule looks like for those parties.
Thank you.
Thank you.
Great. Commissioner Topshin, I think you had your hand up.
Oh, yes, thank you. I was just very quick. Just want to thank also my colleagues from that Ad Hoc Committee, Vice Chair Copeland and Commissioner Ayers. I really enjoyed time working with you both, and I think we have a consensus almost on everything. And that was really great to see your ideas and fresh kind of look on the RSO issues. And I really enjoyed that time. And thank you, Commission, the entire Commission for delegating me also to that to serve at the Ad Hoc Committee. Appreciate it.
Thank you for those comments, Commissioner Maggio. You have the floor.
Yeah, since I think I've only missed 3 meetings in 30 years, I will be missing the 23rd of December. I will actually be out of the country. So it's July 4th.
I move to expel you. I'm just kidding.
I like the humor.
Further comments from other commissioners? Yes, Mr. Montemayor.
I too will be out of town on the 23rd.
Okay, we've got to slimming down. Other commissioner comments or comments about that date specifically? None at this time. All right, I will let everyone know that I'm actually going to be out at the next meeting. So the very capable Vice Chair Copeland will be taking over that seat. So you have 2 weeks to practice in the mirror for that time.
Thanks.
And you're very welcome. So you will, I don't know if I'll talk to you offline. How about that? To give you some tips. And then as to the 23rd of December, I don't know yet. I'm leaning towards I will likely not be present, but I think maybe we will wait till the next meeting, which I'll be absent at. And I will let Vice Chair Copeland know prior to that my travel plans so that going into that meeting, you can discuss what came out from the parties to the appeal and make a decision potentially on the 28th, if that works for folks. Okay, perfect. Any other comments? Yes, Vice Chair Copeland.
Hi, it's not about the 23rd or whether I will be at the next meeting in 2 weeks or not. It's not about that. I just wanted to echo what our housing manager said about the RSO building blocks. I attended the ones for the tenants, and there's a lot of good updated information on those, and they are available online on the site. And the landlord workshops are coming up on the 19th for the basic and the 26th for the advanced. I'm sure there'll be a lot of good information in that too, but anybody that has a chance to look at the city's website and look those RSO building blocks up, there's a lot of good information there, and it's updated, it's current, so some things have changed, and so it's a good opportunity to get all of that. And that's it for me.
Excellent. Thank you very much. Final comments or forever hold your peace. Okay, wonderful. Thank you, everyone. We are moving on to the end of the meeting portion of this meeting. This meeting is adjourned to the next regularly scheduled meeting of the Rent Stabilization Commission to be held on October 28th, Thursday, 2021 via teleconference. This meeting is adjourned. Thank you, everyone.
Good night, everyone.
Good
Have a good
night.
night. Thanks. Bye-bye.
city commission